Hi, Brian Weekley here with Snow Carpio and Weekley. I wanted to talk a bit about labor market preparation. Why do we use labor market experts? We use labor market experts if there's a permanent partial disability of the unscheduled type. I'll do a separate video on scheduled versus unscheduled types of permanent impairment. We're going to talk about unscheduled today. Unscheduled means it's not listed under ARS 23-1044. B, which is a list of scheduled impairments. And unscheduled, what it actually means is that if you have an impairment with work restrictions from a work-related incident and you are suffering a loss of earning capacity because of that impairment, you're entitled to a monthly award. So for example, if on the date of injury you were making $4,000 a month, and after the injury and after the case has been closed, you can only make $2,000 a month, you're losing $2,000 a month. And under that statute, which is 23-1044C, you're entitled to 55% of that amount, and that would be $1,100 a month in that example. That $1,100 a month is paid for life, or until you start making more than, in my example, $2,000, or until you pass away. So it's a lifetime award with certain conditions to it. It's also the basis of any lump sum compromise and settlement agreements or full and final settlements, which again, I've done videos on those and I'll do additional ones as well. But that monthly number is very important because it sets a baseline. It's also probably the biggest money number in the case, so insurance companies and third-party administrators are acutely aware of that number, and there's usually a lot of battling that goes on over that number. Basically, the more money you can make when you're released from your injury, the less money the insurance company has to pay you. If you can make as much as you did on the date of injury, the insurance company has to pay you zero because you have no loss of earning capacity. To prepare for loss of earning capacity, which is an award issued by the Industrial Commission within 3 to 4 months after your case is closed, we normally send your file to a labor market expert. That expert does not work for us. They're hired as an independent expert by us. I tend to use experts that play both sides of the fence. They do defense work and they do claimants work. I think we get a more balanced outcome and a more respected opinion that way. We send your file to that expert. That expert will call you normally and interview you about relevant factors under 23-1044. And those factors include your age, your date of birth, your employment history, your educational history, your work history, whether you've ever served in the military, whether you've been convicted of any felonies, whether you've worked since the date of injury, how many hours you worked on the date of injury, whether you had other employment on the date of injury. Job search is very important. Of that, job search is probably the most important because it's the criteria of good faith effort to find suitable employment, which is an important one. So they'll interview you, they'll produce a report, we'll take the report, and that becomes your position about what we think you should get every month, and we'll submit it to the Industrial Commission. The Commission will issue an award. We can protest the award and take it to a hearing. The other side can protest an award and take it to the hearing. The other side retains an expert as well, so we normally end up with two battling experts. For the labor market expert, just as practical advice, the expert we hire, please cooperate, provide all information because they are on your side. Call with any questions as always, and thank you so much.